Welcome to Prediction News Update. My name is Chris Gerlacher. I'm the senior political reporter and industry analyst for Prediction News. And we waited a couple weeks as there were some minor hearings, procedural things, and some dates set, but nothing that had really changed what we had spoken about some weeks ago. And then the week before we leave for conferences, everything happened. So we're going to catch up on all of that today. If you're here with us, like this video, subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News. Now we're going to finally get into everything with Daniel Wallach, our appellate lawyer extraordinaire and great interpreter of the appellate courts. Dan, I actually want to start with G2E, the big gaming conference we were just at in Vegas together. What were some of your takeaways from that conference? How's the gaming industry looking at prediction markets?
Well, that's all anybody was talking about, seemingly, at the conference. Last year, the hot topic was sweepstakes casinos. And everyone was talking about, VGW and Chumba. Are these legal? Should they be regulated? And that was at the very beginning of the debate around sweeps. A year later, the sweepstakes debate has largely been settled. I mean, a couple more years. I think there's going to be a few more twists and turns and more states passing bans and more attorney general opinions. But it has been knocked off center stage by prediction markets. And I've done, over the past few weeks, a ton of calls, almost all of which have been with equity analysts, Wall Street type people, investment bankers. They converged on Las Vegas. It just seems everywhere you turned, there was someone from JP Morgan or someone else who was a stock analyst. I've never seen the convergence of Wall Street and gaming. I mean, forget prediction markets. Generally, that's a CFTC regulated market, but the interest in the equity markets on this topic, because of the potential impact on some of the large publicly traded online sports betting companies, I mean, it's at a fever pitch. That's all anyone wanted to talk about all 5 days. You wouldn't have even known that there was an expo hall with people, showcasing slot machines and other games in the educational forums, in the halls. Almost every conversation was about prediction markets. At least that's all that I talked about.
That is very similar to what I went through at G2E. Although I did go on to the expo hall and talk to some of the exhibitors, and Steve Reddick had this great tweet that said, once you get out of the education halls and away from the panels, prediction markets do quickly become more of a curiosity. So we had people asking us questions about, where is the industry going? What is this product like? How similar is it to the companies we provide payment options for now? So it was really interesting to see the contrast between the folks who are in the know, who are watching this coming, and who are just waiting to see whether it becomes a viable business for them to partner with sometime in the future.
Well, the land-based casino operators and the slot machine operators are certainly going to care about it much more when Kalshi offers its first, casino contract or slot machine contract. Right now, it's focused on sporting events, and it hasn't really converged in the world of casino. But I think that day is coming. And the talk about all this news breaking the week before we left or the week we departed. How about news breaking when I'm actually on a panel talking? I'm on a sweepstakes casino panel with Howard Glazer, Trace York from the American Gaming Association, Howard's from Light and Wonder, and I was on with Dave Rebuck and Sean Flaherty. And during that panel, the news broke. Well, actually, I had the news. The news broke that the Ohio Casino Control Commission was sued by Kalshi, which became the 5th state to be immersed in litigation against Kalshi. And that came across my email while I was on the panel, and I couldn't do anything about it. So as soon as the panel ended, I ran to my laptop, opened it up, and tweeted it out and read the complaint. But so much has been happening in such a compressed period of time. This is almost it really is. If it's not a daily news cycle, I would think there are multiple key events happening every week.
Well, let's get into some of the state actions. Ohio, Arizona, and Michigan have all sent warnings to their sportsbook operators over the past few weeks and months saying, hey, if you try and circumvent our state sports betting laws with sports contracts, your license is at risk. What do you think about the way that some of these more proactive state regulators are approaching prediction markets with their licensees?
Well, Chris, they kind of run the gamut. They're not all the same kind of threat. Michigan's letter, which was issued, I think, the Friday prior to G2E, which was the most recent letter, I think comes across as the most heavy-handed. I wouldn't use the word heavy-handed, but perhaps the most threatening to the licensees, because Michigan is a state that not only has online sports betting, but also iGaming. So if you lose your OSB license, you're also going to lose your right to offer online casino games, which are, a much more lucrative and bigger handle number in Michigan.
That's where the money is.
Yeah, by ratio of like 3 to 1. So the circumstance or the consequences are much more stark in Michigan. But even going beyond that, Michigan's language was much more threatening. It was, I would say, compulsory that if you are involved in these prediction markets in Michigan or in any other state that objects to prediction markets, it will have licensing repercussions. By contrast, Arizona didn't go quite as far and said, we'll take that into account. So it was less of a threatening letter from Arizona than the Michigan letter, which stood in stark contrast on the opposite extreme, that not only would look at sports prediction markets that penetrated the state of Michigan, but if you so dare, were involved in offering or supporting sports prediction markets in states like Maryland, Nevada, Ohio, Massachusetts, any of those states. I think I counted 10, which were all the states where there are cease and desist letters issued, or the states are otherwise in litigation with Kalshi. If any of those states, if an online sports betting operator or an iGaming licensee or a supplier that's licensed is involved in those markets and in any of those objecting states, it will have licensing repercussions in the state of Michigan. So I don't think all three of them are going to start pulling licenses, but the one I'd be most wary of would be Michigan, given its compulsory language, its geographic scope, and the fact that there's iGaming also at issue here with potential loss of suitability. So that's the real game changer as far as I'm concerned. So how do the sports betting companies deal with this?
Oh, I was going to ask you. I mean, the sports books are in a tight spot because on the one hand, they want their 50 state access. They want that single federal regulator, single tax rate. They don't want to do the monthly license fees, but they also don't want to lose what they have. So they, companies like, I think FanDuel just either this week or this morning announced that it was going to go ahead with event contracts on different subjects, and it's partnered with CME Group. Not sports, though. They're going to wait and see and hold that out. I think they're probably one of the better positioned sportsbook companies that may want to move into prediction markets. But I think everybody's got to move on this tightrope pretty differently.
The concern, I don't think, is to keep what they have. The concern is that the market is going to get away from them. If Kalshi, Polymarket, Crypto.com, and Robinhood gobble up all these states like Texas, California, and operate in all 50 states, and FanDuel and Caesars and DraftKings have to wait 2 years for the Supreme Court to decide the case, the battle of California, Texas, and some of the other open markets will be lost forever. I mean, you have to remember when DraftKings and FanDuel were a fantasy sports operator, they had customer acquisition, in significant numbers before sports betting ever became legal across the United States. So when FanDuel and DraftKings were ready to get licensed for online sports betting, they had a built-in consumer or customer acquisition advantage by virtue of their DFS product. And now they face the prospect of losing that first mover advantage. And the longer that they wait, the more ground that they will potentially cede to not only the Polymarkets and Kalshis, but companies like Prize Picks and Underdog, which have found partners in the CFTC landscape that are going to be aggressively pursuing sports event contracts and have, a significant number of downloads already. I think Underdog may be the most popular, sports related app right now. So they are well positioned to exploit the opportunity, whereas companies that have gambling licenses from states have to be a little bit more wary about the timing. So I think what they do here to thread the needle is maybe there's some geofencing that can go on where if you're, and I'm not speaking about specific companies, I don't know what their plans are, but obviously FanDuel, DraftKings, and every single online sports betting company geofences around states in which they're doing business to ensure that the customer is located in the same jurisdiction where the bet is received. And I think they're going to be implementing some of that same kind of technology were they to venture into the sports event contract market. And maybe there's some geofencing that goes on to stay on the right side of some of these warning letters from Michigan, Arizona, and Ohio. And you can stay on you could avoid violating the Michigan warning if the sports event contracts are offered in California. Well, I don't think the companies are going to do that because of the tribal relationships that are paramount. Mm-hmm. But you could conceivably offer prediction markets in Texas and other states that haven't issued sports betting licenses or haven't objected to Kalshi or any of these prediction markets without violating the spirit and the letter of the Michigan letter. So I think there's a way to walk that fine tightrope through geofencing, back channeling with the state gambling regulators, and just having an ongoing dialogue before you take the plunge. And I think a lot of this may depend, or some of the willingness to move forward may depend on how some of the next couple of court cases get decided, because in the fourth quarter of 2025, I believe there may be as many as 5 or 6 federal court decisions on top of the 3 or 4 that have already been issued. I mean, we're talking Massachusetts on a motion for remand, Ohio on a motion for preliminary injunction. We're going to talk about these. The California tribal case, which is set for hearing next week, that's 3. The Third Circuit decision is 4. And we're going to get rulings in the Nevada Crypto.com and Nevada Robinhood cases, and the Massachusetts Robinhood case. So there may be 7 decisions, twice the number of cases that have already resulted in court rulings. So if you're these online sports betting operators that are focused on fourth quarter, I think you might as well wait until there's more of a judicial track record and you could get a sense of which side is really winning. Has the pendulum swung back entirely in the state's favor, or is Kalshi going to win most of these cases? And I think that picture or that portrait will be filled in a little bit better by the end of this calendar year.
Sure. One of the interesting cases we're watching is, of course, Nevada. Nevada initially granted Kalshi's preliminary injunction. It was Kalshi's first preliminary victory that said, I mean, the federal preemption argument won the day in that case. Well, Crypto.com had a very similar ask for its sports contracts, and it was denied. They did not get their preliminary injunction. Now they have to go, fight the case on its merits. What does that reversal or seeming reversal in Judge Gordon's opinion look like to you?
It wasn't an inconsistent ruling. It wasn't a reversal. When Judge Gordon, Andrew Gordon, he's the chief judge in the U.S. District Court for the District of Nevada. He was the 3rd judge assigned to the case. Prior to recuse themselves, one of the federal judges was married to a gaming industry executive. So I guess in Nevada, it's very hard to find a federal judge that doesn't have some ties to the gambling industry. So when Judge Gordon granted Kalshi a preliminary injunction, it was predicated on 2 factors. The grant of exclusive jurisdiction to the CFTC to regulate contracts traded on its exchanges. I mean, that's not a controversial proposition. But the second aspect, which was the CFTC's inaction on Kalshi's self-certified sports event contracts, rendered it approved, or at least the way Kalshi argued the effect of the CFTC's inaction was that it was tantamount to the CFTC approving Kalshi's sports event contracts. And based on those circumstances at the present time, the judge concluded that because the CFTC has exclusive jurisdiction over contracts on its exchanges, and that the CFTC took no action against Kalshi's sports event contracts, that meant that at the present time, those contracts were legal and therefore subject to the CFTC's exclusive jurisdiction pursuant to Section 2 of the Commodity Exchange Act. He never addressed or determined whether those contracts were in fact swaps as defined in the Commodity Exchange Act. So he based it largely on the fact that the contracts were up and running with the CFTC's acquiescence and therefore must have been legal at the present time. We now know, as a result of the CFTC's September 30th letter, which was their last official act before the government shutdown, that the CFTC hasn't taken a position on whether these sports event contracts fall within one of the enumerated categories in the special rule, in particular, the gaming category. So I guess what we're to read into the later CFTC advisory was that they haven't approved or disapproved anything. They haven't made any determinations. And given the fact, or given the self-certification ability, which is a permissionless environment in which companies can self-certify, receive no objection, and then hit the ground running and start offering sports contracts, that's not an approval. And the outcome of the Kalshi injunction motion may have been a lot different if the judge had reached the swaps, or had analyzed the swaps issue in greater detail and had known that the CFTC had not yet taken a position.
So there are new issues on the table in the Crypto.com case compared to the first Kalshi case in Nevada.
That's right. That's right. Now the judge is, as much as the first ruling seemed to favor Kalshi, I think it was more of a placeholder. The judge used cryptic language, at the present time, and in some subsequent status conferences, he expressed a willingness and an interest in revisiting a lot of these issues, and nothing was etched in stone. So the ruling against Kalshi didn't necessarily bind him or lock him in to how he addressed the Crypto.com motion for preliminary injunction. And by that time, what was different about the crypto case than the Kalshi case is now you have Mayor Brown and its Supreme Court superstar Nicole Saharsky representing the state of Nevada and conducting the oral argument in the crypto case. You have all the Native American tribes, which have now filed amicus curiae briefs in the crypto case, just like they did in the Maryland case and as they did in the Third Circuit case. So the judge now has the benefit of everything he's learned in the Kalshi case, is amplified by the participation of the tribes and the involvement of Mayor Brown, one of the largest law firms in the country. And they obviously did a fantastic job in arguing the issue. And then the centerpiece of the oral argument 2 weeks ago is our crypto's sports contracts, which were self-certified as being based on the outcomes. Do those qualify as swaps? And he answered that question in the negative during the oral argument. And he looked at the statute and he said that according to the statute, the contract has to depend on the occurrence or non-occurrence of an event. But your client's contracts, referring to crypto, state that they depend on the outcome of an event, not the occurrence of an event, but the outcome. And his concern was, if every outcome is an event, then everything is an event, and that couldn't have been what Congress intended. And when crypto's own self-certification basically dug its own grave, they hoisted themselves by their own petard, because under their self-certification filed with the CFTC, they used the word outcome of sporting event. And Judge Gordon said outcome is not the same thing as event. Otherwise, everything in the world, everything in the universe, a coin flip between you and me, that would be an event. And therefore, that could be the subject of an event contract. So that was the line of demarcation. All along, Chris, we've been debating whether sporting events or the outcomes of sporting events have potential commercial, financial, or economic consequences. That's the third sort of clause in the definition of a swap. Nobody was focusing on the first clause, which refers to the occurrence or non-occurrence of an event. We were focused on whether there were financial consequences. And he went backwards and looked at the very first subject mentioned in the definition of a swap. And he said, sports event contracts tied to, the outcomes of sporting events can't be swaps, because that's not an event. That's the outcome of an event, and they cannot be one and the same thing. And that's why he denied crypto's motion for preliminary injunction. And a lot of folks on Twitter, the former CFTC general counsel has criticized that ruling as being too much hair splitting and too fine. And I don't agree with that. I think there is a line of demarcation between an event, the occurrence of an event, and the outcome of that event. I can definitely see a universe where they are different, entirely different things, but I could also understand that that's subject to a fair amount of debate.
Right. Well, we've also been talking about Kalshi in Nevada. They're fighting over discovery right now in their case. Do you think that crypto.com could be the pivotal event contract case that ends up at the Ninth Circuit in Nevada that we end up fighting over in 6 months?
Ironically, yes. And the crazy thing about it is none of us were following the crypto.com case. There are 3 Nevada cases. There's the Kalshi case, there's the crypto case, and then there's Robinhood versus the state of Nevada. And Robinhood has filed an identical motion for preliminary injunction, which is fully briefed as of today, which in turn will probably yield an oral argument and a decision, on the merits of the motion for preliminary injunction. So the court is going to have basically 3 PI rulings covering pretty much the same subject matter, although the Kalshi case didn't turn on the definition of a swap. So from a timing perspective, we're waiting for a decision, a written opinion from Judge Gordon on the crypto.com case. All we have so far is a sort of a docket notation on Pacer, which says that the motion has been denied. A written opinion is forthcoming. And what I've just read to you from the transcript is basically the transcript of the hearing. That's not the final ruling. And when he memorializes his decision in a full-blown written opinion, there may be more reasoning, more details, and more rationale that support his ultimate decision on why he denied the PI and why sports event contracts tied to outcomes aren't swaps. But I think we have enough of an indicator from reviewing the transcript as to how he's going to explain it. But until that written opinion is issued, the order, there's no appealable right. You need an order or an opinion, a decision to appeal from. So I think that's forthcoming imminently. It could be this week or next week. And when that decision is issued, the opinion and order, that's going to be the document from which crypto.com files an immediate appeal to the U.S. Court of Appeals for the Ninth Circuit. And despite getting a later start than the Kalshi litigation, it's going to be crypto.com that gets to the Ninth Circuit before Kalshi, because Nevada never appealed its loss on the motion for preliminary injunction. It decided it wanted to get fact discovery and gain information and documents from Kalshi bearing on, its irreparable harm, the costs and expenses of geolocation, how it arrived at whether sports events involve potential economic, commercial, or financial consequences. So Nevada wants to pursue extensive discovery from Kalshi. In their case probably won't end until the middle to latter part of next year, because the discovery process is going to be at least 4 months long. Already there's motion practice, motions to compel, and following the close of discovery, there'll be motions for summary judgment, cross motions for summary judgment. It'll take the court 3 or 4 months to rule on those, and we're likely looking at a September opinion date. All the while, that crypto.com will be before the Ninth Circuit for close to a year. So you could conceivably have the Ninth Circuit deciding the merits of the crypto.com appeal while the Kalshi lower court case is still pending, and that Ninth Circuit ruling in crypto could have the effect of binding Judge Gordon in not only the Kalshi case, but also the Robinhood case, which may be why you'll see Kalshi participate as an amicus curiae in the crypto.com appeal.
Yeah, there's so much going on in Nevada, but I do want to move on to Massachusetts.
It's good to be an appellate lawyer these days.
Oh man, if you I cannot imagine how well all those Nevada lawyers are doing right now.
I'm a 100% gaming specific attorney now. I don't really handle litigation, but for 20 years of my career, I was an appellate lawyer. I was a complex federal court litigator in appellate practice. So I'm drawing upon all those experiences and knowledge of the practice procedures of courts. I've never practiced in the Ninth Circuit, but I practiced in multiple federal circuits, and they're all governed by the same federal rules of appellate procedure, as sort of with slight subtle differences from circuit to circuit based on local rules. But I'm familiar with all those rules, and it's wild to me. I'm talking to all these MBA types and financial research equity analysts, and they're all asking me inside baseball on judicial procedures and motions for rehearing and what's going to happen, the sequencing, the timing, the process for all these court cases that used to be the kind of conversations one would only have with other appellate attorneys. Now this stuff matters to Wall Street and to the markets.
Yeah, I mean, they're all trying to speak the language of appellate procedure to try and tease out what they, need to be investing in, if they need to be getting in on the game, if they need to be selling off DraftKings FanDuel stock. There are a lot of decisions for them to all make.
But the problem with giving answers is to sort of call back or recall the famous Rowdy Roddy Piper quote. If you're into professional wrestling, just when you think you know the answer, I change the question. Yeah, so that's the challenge in dealing with this moving target of multiple federal court proceedings, new lawsuits being filed, new motions, cases that we didn't even care about now mattering. I mean, who was following Robinhood and Crypto.com in Nevada? You just were making the assumption that why bother it? Why bother following it at all? Because he's going to rule the same way that he did in Kalshi. And it's just, you can book that and not worry about it. And what happened came much to the surprise of everyone, because honestly, I was not tracking the Crypto.com cases closely. And then when I looked at the docket, I said, holy moly, look at all these amicus briefs that have been filed by the tribes. I think the tribes have been as impactful in the prediction market debate as they have been in the sweepstakes casino debate, where they were the reason why California passed an anti-sweepstakes casino bill, and it was signed into law last week. They have been a catalyst and partner in arms with the states, and have made a difference in helping the states sort of maintain an equilibrium in dealing with Kalshi's high-powered council. I think the tribes have brought a lot of muscle and grit and high-powered legal talent to the table, and have leveled, I think, even the playing field a little bit, and given the states maybe the upper hand even in some of these recent cases.
Yeah, well, let's go ahead and talk about the California tribal case. I mean,
all the credit goes to Joseph Webster, Brian Newland. A sort of a cavalcade of tribal gaming all-stars that have participated in the briefing around these issues. So they played a really big role in, I think, blunting the momentum of Kalshi through their participation, as have the commercial casinos through their trade associations in Nevada, as well as in New Jersey, although New Jersey doesn't seem to be going the state's way yet.
Yeah, well, tell us about the upcoming oral argument in the tribal case in California.
Yeah, a quartet or trio of California tribes in the northern part of the state have filed a lawsuit against Kalshi and Robinhood, and have sought a preliminary injunction, filed a motion for preliminary injunction. That motion is set to be heard by Judge Jacqueline Corley in San Francisco Federal Court next week, October 23rd. What date of the week is that? What's today, the 14th? It'll be a week from Thursday at 10 a.m. in court in San Francisco. And the argument here is a little bit different, starkly different than the argument that the states have made. The states are trying to enforce their state gambling laws, and Kalshi is arguing that the federal commodities law preempts state law because of the grant of exclusive jurisdiction to the CFTC. The tribes aren't arguing that. They're arguing that the availability of Kalshi on Indian lands, if you're using a laptop or your phone and you can trade while you're physically within Indian territory, that violates the Indian Gaming Regulatory Act, and which is a federal law, and violates the tribes' exclusive rights to gaming on their own land. And to have for class 3 gaming, which is what sports betting is, to be legal on Indian lands, you need a compact between the state and the tribe to be able to offer it. And none of these Kalshi contracts are governed by compacts. To the contrary, they are in violation or in competition with the tribal gaming compacts, which grant the tribes exclusivity to their own land and the exclusive right to regulate gaming on their own lands. Kalshi, in opposition, has argued IGRA only covers land-based gaming. The Indian Gaming Regulatory Act, by definition, given the prolific use of the words gaming on Indian lands, necessarily refers to land-based gaming operations. And the only statute that applies to internet gaming on Indian land would be the Unlawful Internet Gambling Enforcement Act, otherwise known as the UGIA. And the UGIA has a carve-out. The UGIA would criminalize internet gambling except as otherwise provided. And there's a carve-out in UEJA for contracts traded on CFTC regulated exchanges. Right. So Kalshi is arguing that IGRA only applies to land-based gambling operations. UEJA applies to the availability of internet gaming, even on Indian lands. And in any event, the commodity carve-out under the UEJA gives Kalshi the right to offer those contracts without intervention from the tribes or the courts.
Okay, so what's a rough timeline after oral argument? When do we figure out, how these early tribal cases begin doing?
Well, I'm going, so I'm going to the hearing, and and I can tell you from attending most federal court appellate oral arguments and even district court oral arguments, unless the bench is just a cold fish and just sometimes you get a court that just sits there like furniture and doesn't ask any questions. And I've been part of hearings like that. Maybe it was because of my involvement that the court was like that, but typically the courts ask lots of questions. Mm-hmm. And by the nature of the questions, you can get a sense of how the court is feeling about each side's relative position. So by the end of the oral argument, in the majority of oral arguments, you get a real good sense of who won. It's not an ironclad guarantee, but I would expect to have a good sense by the end of that oral argument. And failing that, the transcript will be available within a couple of days. And since this is a motion for preliminary injunction, using past precedent, I think the New Jersey and Nevada courts both ruled within a month of the oral argument, so we should have a decision before Thanksgiving on the California tribal case. And I think that could be a major inflection point in all of the litigations, because in order to necessarily decide whether IGRA is a more important law than the Commodity Exchange Act, the judge will necessarily have to dive into whether the Commodity Exchange Act, in fact, authorizes sports event contracts, and or whether Kalshi is offering that type of activity without any sufficient congressional authorization. So she could just decide the case narrowly that these contracts being available on tribal lands is a per se violation of IGRA, or she could hold that, but as a run-up to that ultimate ruling, she could determine that these sports event contracts are not authorized under federal law, and in any event are trumped by the tribe's IGRA protections. So depending on who wins and how far her ruling goes, this could have major, potentially far-reaching consequences, even in other cases, because a victory by the tribes, depending on the rationale utilized by the court, will represent a 3-court winning streak for the states and or the tribes. Looking at that case, the Crypto.com ruling, and then the Maryland federal court decision dated August 1st, in which the court denied Kalshi's motion for preliminary injunction. So now you're seeing 2 early Kalshi victories offset potentially by 3 successive rulings in favor of a governmental actor, which could, cause a reassessment of the prospects for success here, and whether some of these sports betting operators, feel comfortable moving forward in prediction markets if the cases start to go south for Kalshi. I mean, I'm getting ahead of myself because we don't know how this case is going to turn out yet in San Francisco. The Kalshi and Robinhood, or the injunction motion is filed only against Kalshi, not against Robinhood. But Kalshi has raised a number of other arguments along the lines of 2 of the 3 tribes don't have compacts. They're governed by secretarial procedures, and those secretarial procedures don't give them sufficient standing to challenge what Kalshi is doing. But assuming that the court reaches the threshold issue on the merits of whether this violates IGRA, I would think that the tribes have a very solid legal argument, because they are not going to be dragged into this federal versus state preemption, legal quagmire. They get to avoid all that and invoke a more specific federal law that actually references gaming and is all about gaming and is more specific than the General Commodity Exchange Act provision, which just talks about swaps without any references to sports betting being sufficiently classified as a swap. And I think when you consider the weight of the 2 federal statutes, I think IGRA may have a stronger impact and overrides the sort of the tacit approval of sports wagering in the Commodity Exchange Act. And I don't think the judge is going to buy the argument that IGRA only applies to land-based gambling operations and not to the actions of the bettor in placing the bet. I mean, we just heard a case a couple of years ago in the DC Circuit involving the Seminole Tribe of Florida's compact with the state of Florida. And that case was West Flagler versus Howland. And the core issue in the case is whether where the bet takes place, but along, as part of the IGRA jurisprudence, it's well settled that the placing of a bet is the gaming activity, not where the bet is received. And even if where the bet is received constitutes a material fact, the placing of the bet by the person or by the customer is still gaming activity. And if placing a bet on a mobile device is gaming activity and you're on Indian lands, that's within the IGRA fairway. And IGRA has been held to apply to internet gaming.
When are some of these states going to hire you to argue on their behalf?
I'm very good at second guessing and reviewing other people's court pleadings and assessing arguments. But I think one of the roles that I think I could play, if I could be the consigliere to state governments, I would suggest, why don't you all pool your money? Because all these state governmental actors, they're constrained by budgetary issues. They can't go out and hire, Mayor Brown, or maybe Nevada could. It's an expensive undertaking. State attorney general's offices have budgets, and they also have hundreds of attorneys that are looking to be busy. So it's natural to insource the work to your local state attorney generals, assistant AGs, or deputy, solicitor generals. But all these states should be hiring the same law firm. You should be working with Nicole. So if you're Arizona, Ohio, Massachusetts, have the AG's offices involved, but also bring in Mayor Brown, bring in Paul Clement, the former U.S. Solicitor General from Clement and Murphy, who, the firm which handled, or the lawyer which handled the PASPA case on behalf of the sports leagues. Get a high-powered attorney who can match wits with Kalshi, and also effectively position this case for Supreme Court review. And I think what the state should be doing is hiring these law firms, all using the same firm, pooling their money, and hiring one law firm to represent multiple states in all these different federal court proceedings. Or alternatively, have the licensees, have the sports betting companies, have the tribes, have the casinos underwrite the cost of the litigation, because ultimately this is going to be for their benefit or detriment. And while the state faces the loss of tax revenues and it is a consumer protection issue, this is also a matter of salvaging the relevancy of the state licensed gaming and sports betting market. And were that to get away, the ones who would pay the steepest price are the companies licensed to offer these products, not being able to compete on a level playing field with Kalshi, Polymarket at all. So I think the state should be using outside counsel. They should also pool their resources and also look to their licensees to underwrite the costs of these litigations. And were they to do all those things, and this is the role that I could play, if they were to listen to Wallach's three-point plan, I think they would pretty much win every case.
And are you looking for gigs?
Probably more influence than gigs. I have enough gigs. Right. And I'm not saying I've had these conversations, but if you read my timeline, I've been fairly open about what I think has been a tactical mistake by state governments in going head to head with Milbank, using your state attorney general's line attorneys. I mean, the Massachusetts AG court filings have been impeccable. So I don't mean to paint with a broad brush, but why don't you have both? Why don't you have the attorney general's office working in the trenches alongside a major national powerhouse law firm with U.S. Supreme Court expertise? That's what New Jersey did in Christie versus NCAA. They had the New Jersey AG's office and Ted Olson. Even though Olson was the principal attorney, it was a joint effort. Olson argued the case and ultimately won sports betting for the state of New Jersey. Now, if it was important enough to hire Ted Olson to win the right to get sports betting, isn't it equally important to have someone of that ilk to salvage the relevancy of that market? I would think that it's really two sides of the same coin. And the operators would be foolish not to underwrite the cost of that litigation, because ultimately this is going to be for their benefit. And if they lose, they'll never recapture that market unless they join the CFTC.
Right. Let me drag you into one more state versus federal quagmire real quick.
I got ahead of myself. I got on a roll, and that's why we should do these podcasts at 4 p.m. Eastern time when I'm my local drug of choice, which is my wife's cappuccino.
No, we love Fiery Dan here, but Massachusetts has been fighting to keep their case, or the Kalshi case they have, in state court. Kalshi got it removed to federal court. Tell us about that skirmish, if you would.
Yeah. The Massachusetts lawsuit is the first one where a state sued Kalshi. In every other instance, Maryland, Nevada, New Jersey, the state issued cease and desist letters, which gave a compliance period or compliance deadline. And Kalshi, prior to the expiration of the deadline, preemptively being sued in federal court, narrows the scope of the lawsuit to just be about preemption and not about the legality of the contracts under state law. So this is the first time a state has been able to jump the gun and sue Kalshi without giving an advance warning and make the case about the violations of state law rather than the overall preemption issue. And Massachusetts, at the same time, it filed an emergency motion for a preliminary injunction, seeking to block Kalshi from Massachusetts and to get damages and civil penalties. And Kalshi wasn't successful in removing the case to federal court. It's an automatic removal, simply by filing a notice of removal alleging what federal question or federal causes of action are prevalent here, that it is truly a federal case rather than a state case. So the debate now is, which venue does the case belong in? Because following the notice of removal, the Commonwealth of Massachusetts filed a motion to remand it back to state court, arguing that Kalshi will not be able to meet its burden of demonstrating complete preemption, which is a higher standard on the issue of removability and remand versus the preemption analysis that governed the original cases involving Maryland, Nevada, and New Jersey, where Kalshi had to demonstrate either implied preemption, field preemption, or express preemption. Now, to avoid a remand, they have to go up to level 10 and argue complete preemption, which entails being able to demonstrate to the court that the state has a comparable federal cause of action against Kalshi. And I think it's debatable whether such a federal cause of action exists. And even if this were governed under the ordinary preemption principles, I think Massachusetts has a very strong argument based on the Maryland federal court analysis of applying the presumption against preemption in fields that are traditionally regulated by the states, such as gambling, and by pointing to the existence of the Wire Act and PASPA as representing a strong federal policy of disfavoring sports betting. To overcome that presumption, Kalshi would have to point to language in the CEA, which is clear and explicit of Congress's intent to not just give the CFTC exclusive jurisdiction over contracts on its exchanges, but in particular on sports gambling contracts. And I think that's an analysis that favors Massachusetts, whether it's under a complete preemption analysis or a field preemption analysis. And I think the Massachusetts Attorney General's office has seized the day or seized the moment by following the analytical path or the roadmap that was utilized in the Maryland federal court decision by highlighting the presumption against preemption, which is really making Kalshi's job a lot more difficult, because the standard is now much more stringent for Kalshi, and having to overcome that strong presumption of preemption while also demonstrating that there's complete preemption. And given my research and review of past Massachusetts cases involving motions to remand where the issue of complete preemption has come up, most of those cases are decided in favor of state jurisdiction as opposed to federal jurisdiction. But each case turns on its own facts, on its own statutory regime, and it could go either way. But I think I give Massachusetts a slight edge, given the heightened standard of complete preemption, as well as the strong presumption against preemption. It's an uphill battle for Kalshi to keep it in federal court. And the real downside risk for Kalshi is if they lose on the motion to remand, that order is not appealable.
And when is when's the hearing on that?
There's briefing the motion, I think Massachusetts filed its motion for remand. Kalshi has, I think, 10 days to file its opposition to the motion for remand. I don't know. I don't think that they filed it yet. But there's also a parallel case also being heard, brought a preemptive lawsuit brought by Robinhood against the Commonwealth of Massachusetts. That case is being orally argued on November 12th on Robinhood's motion for preliminary injunction, arguing that federal law preempts state law. So in reliance on the court date that Robinhood has secured, both Kalshi and the Commonwealth of Massachusetts have requested that Massachusetts's motion for remand be heard at the same time because they involve overlapping and similar issues. So in all likelihood, the Massachusetts federal court will have a double header on the morning of November 12th and probably rule within a 3 to 4 week period.
Wow.
If not sooner, which means that we could have a determination on where the venue is going to lie before Christmas. And if this case gets remanded to state court and Kalshi cannot appeal that ruling and has to then face a motion for a preliminary injunction based on violations of state gambling law in front of a state court judge without being able to offer a viable preemption defense, their goose is cooked. And they will lose, and they will face the prospect. They, meaning Kalshi will face the prospect of its first loss on the merits in having an offensive motion for preliminary injunction granted against it, the effect of which would be to require Kalshi to geofence around Massachusetts. The only caveat, or the unless here, is Kalshi would have to obtain a stay of that order or a stay of the enforcement of that order pending appeal. And if they're stuck in state court, they're probably going to have to ask the state court judge for an emergency stay pending appeal. That's going to be denied. Then they go either to the Massachusetts Supreme Court, or maybe there's an intermediate state court. I'm not sure. I'm not a Massachusetts practitioner, but this could go all the way up to the U.S. Supreme Court on the shadow docket. So were they to lose an injunction ruling before having to geofence around Massachusetts, they're going to get 3 bites at the apple to get a stay pending appeal, assuming the case is remanded to state court. And it could take upwards of 1 to 3 months before we find out how all of those stay requests will be decided. And it's possible that in a worst case scenario, by the end of the first quarter of 2026, Kalshi may have to be out of Massachusetts. But that requires losing the motion to remand and then losing 2 successive stay requests before the state appellate court and the U.S. Supreme Court. Or alternatively, the case could stay in federal court and the court might still rule in favor of Massachusetts, which harkens back to the Roddy Piper quote, just when you think you have the answer, I change the questions. And all these outcome scenarios are impacted by other outcomes, and it becomes this constantly moving target.
Yeah, there's a lot of complexity in those cases to watch over the next few months. We've covered a lot of ground today. Is there? Do you have any final thoughts that you want to hit before we wrap up?
The government shutdown, right? I mean,
we are on day 14.
The government shutdown.
Kalshi does project it to go at least 35 days now.
But the more important point is what's going on at the CFTC, right? Even before the government shutdown, they're down 5 commissioners to 1 commissioner. There's a whole brouhaha over who's going to be the next chairman, but they still only have 1 commissioner. Through the DOGE job cuts, the commission has lost 28% of its workforce as compared to roughly a year ago. They're down to, they had 699 employees a year ago. Now they're down to like 550 or 560. And as a result of the shutdown of the federal government, the agency's operations have been ground to a halt, with the exception of every employee has lost access to his or her emails, and only 31 people are basically running the entire CFTC, which is supposed to regulate sports event contracts. In other words, the total working staff of the CFTC, which has to deal with like wheat, corn futures, and all these other things, and now sports betting, the staffing at the CFTC is smaller than the staff of the Rhode Island Lottery, which is the smallest state in the country to regulate sports betting. And it does kind of provide context for Kalshi's advisor, Sarah Slane's comment recently to the Nevada Independent, in which she said, it's just one of the most insane comments I've ever heard in my life. She used to be a lobbyist for the American Gaming Association. She worked for MGM.
Right.
She's historically always taken the position that the federal government should stay out of gambling and that the states, the tribes, and the lotteries are best suited to regulate gambling and sports betting. And that was her party line for 3 weeks. And there's a great column today in a great piece from Steve Ruddock in his daily Straight to the Point, where he highlighted her recent comments on the federal government being better suited to regulate sports futures than a collection of state slot machine regulators. She just insulted every state gambling commission by calling them nothing more than mere slot machine regulators. And she's sort of she's elevating the ability of the federal government to regulate sports futures at a time when the agency has basically shut down its operations, doesn't have any gambling related protocols, doesn't have any sports related integrity protections. And we're supposed to believe that this shallow agency, which is not even operating at full efficiency during a shutdown, can do a better job than the New Jersey Division of Gaming Enforcement or the Nevada Gaming Regulators or the Massachusetts Gaming Commission. So I think it's very important to understand what we're dealing with here in discussing federal regulation. And not all federal regulation is created equally. The federal regulation that is involved here is not yet ripened into one that is well suited to deal with the unique issues surrounding sporting events. And we're a long way from reaching that eventuality while we have only one commissioner without any rulemaking authority and the reluctance of the agency to even engage in rulemaking, knowing that any rulemaking around sports contracts could open the door to Administrative Procedure Act federal lawsuits challenging the agency's authority to regulate sports gambling. So there's a lot going on here, and I think we need to do podcasts more than every 3 weeks, given the pace of things. In the next couple of weeks, I think we're going to have as many as 6 court rulings. The Third Circuit.
Very busy fall.
Yeah, let's say for fourth quarter, we're going to have Third Circuit decision. We'll have 3 Nevada. We'll have 2 more Nevada court rulings, Robinhood, Crypto.com. That's 3. We'll have the tribes case in California would be 4. Massachusetts remand hearing 5. If it's remanded, we'll have a preliminary injunction ruling. That's 6. And then the Ohio lawsuit, which we really haven't discussed at great length, will likely be heard on Kalshi's emergency motion for preliminary injunction, with a decision likely to occur before the end of the calendar year. So that's 7 cases compared to only 3 decisions which have been rendered thus far. So if I'm a licensed operator, I would say, let's hold your horses. Let's see what the scorecard looks like on December 31st.
Well, Merry Christmas to America's lawyers. Well, Dan, thanks for stopping by and breaking all this down for us over this hour. If you're still here with us today, give us a like, subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News as we break down the slew of legal developments coming up.
And more wrestling quotes.
And more wrestling quotes.
Yeah, I've got like a whole childhood of WWF references, IWA references. I'm talking, Los Angeles professional wrestling with Classy Freddie Blassie and John Tolos. I can dig into the well and go all the way back to the early 1970s. So just try me. I've got like a book full of great wrestling quotes.
Well, the sponsors are lining up. So, Dan, thanks again.
You got it. Thanks, Chris.